Okay, Gruber versus SM News Company out of my remedies book from 1954 in New York. District Judge Murphy gave the opinion. Plaintiff seeks, so it's annotated. Plaintiffs seek damages for breach of contract. Plaintiffs allege that a contract between them and defendant was made whereby plaintiffs promised to manufacture, in conformity with samples approved by defendant, 900,000 sets of 12 Christmas greeting cards for the impending Christmas season, to pack every set in a box of design approved by defendant and be sent to a list of wholesalers to be furnished by defendant not later than the second week in October, to give defendant exclusive sale and distribution rights to these sets. According to plaintiff's complaint, the consideration of their promises, defendant bound itself to exercise reasonable diligence to sell all of the sets and use its resources for scientific sales, promotion, national advertising, news stand outlets, and sales organization. Defendant further agreed plaintiff's claim to pay 84 cents for each set FOB. Its wholesalers' respected places of business where, according to the defendant's regular checkup, the cards had been sold at retail. Credit was to be allowed for all sets returned to plaintiffs unsold. It is further alleged that plaintiffs manufactured and packed the sets in accordance with the agreement, notified the defendant to this effect on October 2 of 1942. 5, and that defendant then refused its promised performance. Damages for $101,000 are demanded. For breach of contract of exclusive distribution and return, plaintiffs should be entitled to damages measured by the differences between what they actually obtained for their cards and what they would have obtained had defendant exercised its promised reasonable diligence. Promised reasonable diligence. On this, plaintiffs have the burden of proof to the extent of a reasonably certain and definite factual basis of computation. Under the evidence, such basis in this case is too speculative for an award in a sum certain. Past experience of the defendant in distribution of high proportion of jigsaw puzzles, maps, and cleaning fluids is hardly a basis for prophecy with respect to Christmas cards, and a single retailer's opinion that he would have disposed of 50 boxes of the cards is a precarious foundation for generalization with respect to 900,000 such boxes. Accordingly, plaintiffs have not sustain their burden of proof with respect to their expectation under the breached agreement. However, alternative to damage for loss of their expectation, plaintiffs have demanded at the close of trial at least their out-of-pocket expenses. And the basis for these damages is not plaintiffs' expectation of profits, but rather their expenditures made in essential reliance upon defendant's promise. Defendant, for its part, insists that there can be no recovery upon this theory of essential reliance because there would have been a loss of plaintiffs had defendant fully performed its promise of distribution, which makes sense. And the few cases in point in New York are apparently not entirely in accord with respect to the relationship between anticipated loss and event of full performance by the defendant on one hand, and a plaintiff's recovery of his out-of-pocket expenses in reliance on defendant's unperformed promise on the other. There are situations where there is no such relationship, and a plaintiff may recover his expenditures in reliance upon defendant's promise without regard to profit if that promise had been fully performed by defendant, as in actions for restitution and ones based on fraud. The restatement has suggested that if full performance by defendant would have resulted in loss to a plaintiff, then his loss must be deducted from plaintiff's expenditures. We accept as the rule that plaintiff's recovery for their out-of-pocket expenses must be diminished by any loss that would result from defendant's full performance. We are not persuaded that defendant has established the probability of such loss. True, plaintiffs were able to obtain merely 6 cents per box on a sale of 40,000 boxes in 1949, rather than the promised 84 cents for sale in 1945 under their agreement with defendant. But that's interesting. It's 4 years later. But the Christmas cards had a novelty appeal designed as they were to exploit a dozen different nations at a time of the newly formed United Nations in 1945. The glamour of the caricatures may well have been clouded by the worsening world situation that gathered in the succeeding years. The burden of proving loss and event and performance properly rests on the defendant, who by its wrong has made the question relevant to the rights of the plaintiff. We do not find that defendant has sustained this burden. Only the amount of plaintiff's expenditures reasonably made in performance of the contract or in necessary preparation therefor may be recovered. This does not include, as plaintiffs have requested, the cost of making the plates from which the cards were printed, since these had already been fabricated prior to making the contract with defendant. The amount of plaintiff's expenditures for labor and material reasonably made in essential reliance on defendant's promise was $19,934.44. From this sum must be deducted the net amount realized by plaintiffs from sale of 40,000 sets at 6 cents a set, which was $2,080. Accordingly, plaintiffs are entitled to $17,854.44 in damages judgment accordingly. I'm going to just roll through the case notes after this case. The reliance alternative, note 1, reliance damages and expectancy damages are alternative measures of recovery. Thus, the non-breaching party generally cannot recover both. Gulf Group General Intercompany WLL versus United States Federal CLCT 2013. Instead, the breaching party recovers reliance damages because it is unable to prove its expectancy with reasonable certainty. Thus, in the principal case, the manufacturer's expectancy interest for breach of the exclusive distributorship agreement measured by the difference in value between the performance promised by the defendant and that which was actually received would have been the profit the manufacturer would have earned on the sale of greeting cards. However, since the plaintiff could not sustain its burden of proof on expectancy damages with reasonable certainty, the alternative measure of reliance damages was sought. The reliance damages often will be less than the expectancy damages because the profit of the non-breaching party is not included. Losing contract. As the court in the principal case notes, a non-breaching party's reliance damages are reduced to the extent that the breaching party can prove the plaintiff would have sustained losses in the event of full performance. This is note 2, by the way. If the contract includes a set price and the non-breaching party expenditures exceed that price, the breaching party will be able to establish a loss with certainty, and the court will limit the amount of reliance damages recoverable not to exceed the contract price. The rationale for such a limitation is that expenses incurred above the contract price certainly would have been losses sustained by the plaintiff and therefore are properly deducted from the total recovery. Cases such as the principal case present more challenging issues. What losses would the defendant have sought to establish? How difficult would it be for the defendant to demonstrate such losses would have resulted? What information would be relevant as evidence on the issue of the plaintiff's potential losses? Consider DeAndrea Bros. LLC versus United States in 2013. In DeAndrea, the plaintiff entered into a contract with the U.S. Army to help commercialize a nutritional energy bar developed by a U.S. Army researcher. Under the agreement, the Army granted the plaintiff an exclusive 5-year license to use the trademark name of the energy bar in exchange for royalty payments. The trademark name was similar to the name which the Army used for its version of the energy bar it included in soldier rations. The plaintiff brought suit for breach of contract after the Army failed to inform the plaintiff that the Army was changing the name of version included in the Army rations. At trial, the plaintiff demonstrated that its cost in attempting to bring the bar to market during the 5-year license period exceeded its revenues. The plaintiff sought to recover the difference between the expenses and revenues. The court concluded that the Army had proved to a reasonable certainty that the plaintiff would have lost its reliance expenditures despite the breach. The Army presented evidence that the plaintiff was aware that it could only rely on exclusive use of the trademark name for 5 years and that it would be difficult to establish brand recognition in 5 years. The Army also presented evidence that the plaintiff began to experience brand recognition problems before the Army formulated plans to change the name, that the plaintiff's commercial sales began to decline before the breach. Finally, the Army established that it did not change the name of its version of the energy bars until the very last months of the exclusive license period. Note 3, essential reliance. The court in the principal case awarded damages for essential reliance. These damages typically include expenses incurred in preparation for performance or in the actual performance of the contract. Incidental reliance damages, in contrast, may be described as expenditures made in preparing for collateral transactions apart from the contract. The difference in classification may be seen in cases involving new business ventures. For example, assume that O entered into a contract with the XYZ construction company and build a restaurant. If O breached the contract after XYZ had partly performed, the builder could recover as essential reliance damages the expenditures made in preparing to perform and in commencing performance. If, on the other hand, the builder breached the contract, purchases made by O toward furnishing the restaurant would be characterized as incidental reliance. The significance of the distinction lies in the role that foreseeability plays as a limitation on incidental reliance damages. See generally Fuller v. Purdue, The Reliance Interest in Contract Damages, Yale, 1936.